Hi, my name is Andrew Meinzer of Meinzer Law Firm. Today I'm going to talk with you about how to make probate simpler through the Independent Administration of Estates Act. A California probate decedent's estate court proceeding, or simply probate, is required to transfer the assets of a decedent if the assets at issue exceed a certain value amount. A California probate is restrictive, cumbersome, and lengthy. The Independent Administration of Estates Act, or IAEA, is designed to streamline the process, at least a little. The IAEA removes the requirement that you as the executor or administrator in charge of the probate must obtain court approval prior to taking certain actions. There are two levels of IAEA authority: full authority and limited authority. Full IAEA authority provides you, the executor or administrator, with authority to do anything without prior court approval, except that you do need to obtain prior court approval of the following. 1. Paying yourself executor or administrator fees from the probate estate assets. Paying fees to your attorney from the probate estate assets. An account petition pertaining to your acts as executor or administrator of the probate. Distributing probate estate assets to beneficiaries, and you being discharged as executor or administrator, although there are some of the limitations and exceptions to that one. Plus, generally there are 6 types of other acts of self-dealing involving probate estate assets, paying, trading assets with, or otherwise benefiting you as the executor or administrator or your attorney. Now, limited IAEA authority provides you as the executor or administrator with a few additional limitations. In addition to those actions that require prior court approval with full IAEA authority, with limited IAEA authority, you need to obtain prior court approval of selling probate estate real property, exchanging probate estate real property, granting an option to purchase probate estate real property, and borrowing money with a loan secured by probate estate real property. For all actions other than those specific actions that I just mentioned, normally you simply mail a notice of proposed action to all parties interested in the proposed action instead of obtaining prior court approval. And you must state in that notice of proposed action the specific date on or after which you will take the proposed action, and that date must be at least 15 days after you mail the notice of proposed action. And you must file the notice of proposed action with the court, that way the court knows what's going on. Then, if none of those parties objects to the action that you described in the notice of proposed action within the required time period, they cannot object to it later. That enables you, as the executor or administrator, to take that proposed action safely and without prior court approval. Finally, whether you have full or limited IAEA authority, there are many actions that you can take without prior court approval and without even mailing and filing a notice of proposed action. Now, IAEA authority is not automatic. You must specifically request full or limited IAEA authority to obtain it. Normally, you do this through the petition for probate that you filed with the court. The petition for probate is the first pleading filed with the court that initiated the probate court case. And through it, you also requested that the court appoint you as executor or administrator. Now, a decedent can prevent you from obtaining IAEA authority, but the only way that they can do that is if they have a will and the will expressly prohibits IAEA authority. At Meinzer Law Firm, we have over 20 years of experience helping clients achieve their goals in probate cases. Again, my name is Andrew Meinzer of Meinzer Law Firm. If you know that you need our help, or if you just have a question, please contact us and let us take care of you.